One of the most common questions I get from people who have a great business idea is what they should do first: form their business entity or register their trademark. The answer may surprise you. Let's get to it. Hi, my name is Jim Hart. I'm the founding attorney here at Hawthorne Law, where we help online businesses get their legal house in order so that you can focus on what you do best, and that is building a business that truly matters in the world. Today, we're going to talk about what to do first: form a business entity or register your trademark. Many online entrepreneurs feel like they need to get their trademark registered as quickly as possible because they want to make sure their business name is protected once they go public with their idea. Unfortunately, this isn't always a smart move. As a lawyer, I'm all for doing everything you can to protect your online business, but sometimes holding off on filing a trademark application is actually a smart thing to do. Now, I know what you're going to say. Failing to register your trademark can be problematic. Competing businesses could, theoretically, start to sell under your business name or even file a trademark application out from underneath you. You are probably already aware that the trademark system is a first-to-file system, which means that the first business to file for a given trademark will presumably have priority over that trademark. I say presumably because it is the business that first used the trademark in commerce that has priority. But if you file your application with the U.S. Patent and Trademark Office first, regardless of when you use that mark in commerce, you will have what's called constructive use of that mark, giving you nationwide priority. Can you hear that? They're out there like every 5 minutes. All right, break time. All right, I think they're gone. Now they're in the front of the office. I can close the door. All right, so where was I? I think I was talking about the fact that if somebody basically steals your mark and files first with the trademark office, they would have what's called constructive use, meaning they would have nationwide priority over that mark. So basically, if someone steals your mark and then files first with the U.S. Patent and Trademark Office, you would have to take them to federal court and prove that you were using the mark first, which is an extremely costly and honestly less than ideal situation to find yourself in. So based on what I just said, you're probably thinking that filing your trademark application first is the right way to go then, right? Actually, no. Here's the deal with trademarks. The owner of the trademark, also known as the applicant in the trademark application, is the business that currently or intends to actively use the mark in commerce. What that means is if you are the applicant for the trademark application, the only person that can file that application is the business entity that owns the mark in commerce. But to own the mark in commerce, you have to have a business. I realize this doesn't make a whole lot of sense because a lot of people start out as sole proprietors. So they think that it's just themselves personally that is using the mark. And when they file their application, they file it with themselves personally as the owner of the mark. But this is a bad idea, and here's why. If you haven't formed your business entity yet, then most people will make the mistake of listing the owner of the trademark as I just said, the person who is starting the business. A trademark application must be filed by the entity that is the owner of the mark as of the application filing date. If the applicant, in other words, your business, does not own the mark on the application filing date, then the application is void. And what so many people do is they will file the application with themselves personally as the applicant on the trademark application, meaning that as soon as they file that application, it's void from the very beginning, meaning you're never going to get a mark. And this means that you could waste months of time waiting on a trademark that will never get registered because of this one simple and honestly stupid mistake. Now, is it possible that you could start your business as a sole proprietorship, file your trademark application with the sole proprietorship as the owner, and then assign the trademark later on to your LLC after you form that LLC? Yeah, honestly, that's something you could do. However, I think it is easier just to form your LLC first. If forming an LLC is something you want to do, and then use that LLC to file your trademark application. In other words, the LLC would be the applicant on your application for that trademark. Now keep in mind that getting a trademark registered is not an easy thing to do, and it can take anywhere between 9 to 12 months or longer to get completed. And if any problems come up, it could take even longer. So do yourself a favor, get your business set up first and then file your trademark application. You will thank me for this advice and you'll be happy you did. If you think this video was helpful, here's another video that will help you decide whether you should move forward with filing your LLC or stay as a sole proprietorship. See you in that next video. Have a great day. Talk soon, folks.